in the matter of the marriage of Kendra Lee Pirtle and Jason David Pirtle.
Kendra Lindsay, formerly known as Kendra Pirtle, appears along with attorney Shannon Cooper.
Jason Pirtle, the respondent, appears by and through Susie Locke. Also present in my office is Julie Pirtle, who is Mr. Pirtle's new spouse.
All right, very well. This matter comes before the court at this time for further proceedings in regarding to a motion to modify the permanent parenting plan that was filed earlier by Jason in the case. What is the current status of this, Ms. Locke?
Buckle up, guys. Today we are going to dive into a tense courtroom scene where the Pearl divorce case kicks off. Right from the start, the judge sets the tone, laying out the matter and who's present. You can feel the stakes instantly as attorneys and family members are introduced, and the stage is set for a battle over parenting time, schooling, and custody decisions. This is where viewers immediately get the context and tension of the unfolding drama.
Your Honor, the issues remain largely unresolved. Miss Pirtle relocated to Cheney. She was homeschooling the children. Just for a little frame of reference, I guess, the parties used to live about a mile apart from each other. So when they got divorced, mom was able to continue to homeschool the children. Dad brought the children to her on school days during his parenting time. And they went to school, and then they went back to his house just like they would a normal school setting. Obviously, when mom moved to Cheney, that became completely disrupted. The parties are still doing a 4 days on, 4 days off schedule for parenting time. And right now, the children are bringing their schoolwork to dad's house if he has them on school days. And my client's new spouse, Miss Pirtle, is doing the homeschool work at her home during the parenting time. Otherwise, the issues in our motion have been unresolved.
What are the other issues in your motion?
We asked for the children to move to an online schooling system so that there was some consistency in school, so that the parties would be on the same curriculum and there wouldn't have to be this travel back and forth of the school work. Since filing the motion.
Here, the real problem emerges. Mom moved an hour and a half away, completely disrupting the kids' homeschooling routine. The court hears about the travel, scheduling, and impact on daily life. This section is crucial because it paints a vivid picture of the challenges the family faces and why the case is far from settled. You can see how logistical issues amplify the emotional and practical tension for everyone involved.
The kids went through some testing to determine what grade level they are at. The youngest child, who is 9, tested at a kindergarten level. And so obviously that's pretty concerning. So we would like to move to a standardized school system and an online Christian school system, and hopefully get the kids back on track.
All right. Are there other issues besides that?
Transportation, but the parties have kind of tentatively been working through a plan on transportation.
All right. Ms. Cooper, and I'm not sure why Kendra's not fully on the meeting with us, but she appears to be on with perhaps audio, but not video.
Okay.
Ms. Cooper, why did your client move to Cheney?
Your Honor, she and her husband relocated fairly recently. They had an opportunity for better housing. They think it's better for the entire family. It's closer to extended family on her side. She wants to continue homeschooling the children. It's been consistent with her. She has reservations about the proposal made by respondent and Ms. Locke as far as the program that they're suggesting. She doesn't think it's best for either of the kids who are involved in the homeschooling. She knows that there are issues as far as testing at this point, but she's been working with him. She feels like she's in the best position to continue to be the provider of the schooling. As Ms. Locke stated, we haven't really resolved any of these issues. She and I have talked somewhat about it. My client's proposal would be continue homeschool.
The suspense spikes when counsel reveals the youngest child, just 9 years old, is performing at a kindergarten level. This alarming fact immediately raises red flags, making viewers question the current educational arrangements. The attorney's push for an online school adds urgency, as it suggests a potential solution while highlighting the gaps in the kids' current learning environment. The stakes are clearly high here.
With her, potentially the scheduling would need to change to where the kids are over at respondent's home less often, but perhaps it could be more consistent with what the days that he's actually off from work. On the 4 days when he's not having to have the obligation to be at work, he can actually be there for the kids. So that's more along the lines of what she thinks is in the kids' best interest, and mainly consistency with the schooling, instead of having to change to some new program as respondent has suggested. She thinks that they can continue to make the progress in the program that she's already conducting with them.
Except one of the children clearly is not making progress with the current educational program. Would you agree?
Well, she understands that he has issues, but she's in the best position to help him through those.
Did I hear right that a 9-year-old is performing at a kindergarten level?
Yes, Your Honor.
Just the court's initial reaction would just be, it sounds like she's already had time to bring this child up to an appropriate grade standard in comparison to age and hasn't been able to do that. What's going to change so dramatically that he's going to get caught up?
Well, and Your Honor, we may need to explore some other alternatives, or maybe alternative testing. That I don't know the details on the testing that Ms. Locke is referring to. I think there may be some more there. He may not be quite as behind as is indicated by Ms. Locke. So, and like I said, she can work with him. She's worked with other kids in the family in the past, gotten them through school.
Okay. So I suppose this begs the question, where do we go from here, Ms. Locke?
Right.
Your Honor, I think we're going to have a hearing. I'm ready to argue today about why we should modify to the online school system. But if Ms. Cooper's client's position is that my client should have less parenting time so that she can continue to school the children, obviously we would have a major objection to that. And no response has been filed to our motion, so we don't precisely know what Ms. Lindsay's position is. Additionally, Your Honor, since the move, it's been about a month. It is a lot of drive time for these kids. So that is something that me and Ms. Cooper definitely need to discuss. Every 4 days, they are traveling back and forth from Cheney to Atlanta, Kansas. So it's a pretty significant amount of time that they're spending on the road.
That apparently is a reality of the current situation, though.
That because Miss Purtle moved away, or Miss Lindsay moved away. That's accurate.
All right, Ms. Cooper, do you see things differently? I will need you to unmute yourself, though, if you're going to talk to us.
I'm sorry. As Ms. Locke indicated, I agree that
Now the debate heats up. Mom's attorney strongly defends the homeschooling plan, emphasizing consistency and her unique ability to support the kids. This segment is packed with strategic arguments, as she explains why a new program isn't necessary. The courtroom tension builds because the judge, opposing counsel, and viewers are left weighing whether continuity or intervention serves the children best.